India Legal presents Courts Roundup.
Hello, I am Tanya and you are watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here are the headlines. Supreme Court dismisses plea for removal of Andhra Pradesh CM Jagan Mohan Reddy, says similar prayer being heard in another plea. Supreme Court rejects Chanda Kochhar appeal against her sacking as the bank's CEO. Court declines to interfere with Bombay High Court order. Madras High Court summons Police Commissioner and DGP in hearing of petition for criminal action against former Judge CS Karnan. Delhi's high-powered committee extends interim bail for prisoners for 45 more days to contain the spread of COVID inside prisons.
India Legal presents Courts Roundup.
The Supreme Court has dismissed the plea filed by GS Money and Anti-Corruption Council of India Trust seeking action against Andhra Pradesh Chief Minister Jagan Mohan Reddy for writing and publicizing a letter containing allegations against senior Supreme Court Judge Justice N.V. Ramana.
The Supreme Court has dismissed the plea seeking appropriate action against Andhra Pradesh Chief Minister Jagan Mohan Reddy for making public allegations against Justice N.V. Ramana, the second senior-most judge of the Supreme Court. A bench of justices S.K. Kaul, Dinesh Maheshwari and Rishikesh Roy observed. The petitioners have made a dual prayer. The first prayer seeks to say that a senior-most sitting judge of the High Court or the CBI should look into the scandalizing remarks made by the Chief Minister of Andhra Pradesh. The second prayer is for issuance of writ of quo warranto, and that, in view of the statements made by him, he is not entitled to hold the office of Chief Minister. The second prayer legally would be not maintainable. Insofar as the first prayer is concerned, it seems that the petitioner is himself not clear as to what he wants. The issue raised with regard to the communication between the CM of Andhra Pradesh and the CJI in public domain is already being referred to the bench which is dealing with this aspect. Though pertinent, we see no purpose in entertaining the present petition and hereby dismiss it. Two practicing advocates had moved the Supreme Court seeking action against Chief Minister of Andhra Pradesh, Y.S. Jagan Reddy, for falsely accusing second senior-most judge of the court, Justice N.V. Ramana, of interfering with the administration of justice. The petitioner advocate GS Money told the court that the scandalizing remarks by Jagan Reddy were an abuse of his constitutional office and that they attacked right at the independence of the judiciary. The petitioners further stated that Reddy has attempted to lower public confidence in the judiciary for his personal gain, as he himself is facing many number of criminal cases with the CBI and the court. On October 11, Y.S. Jagan Mohan Reddy, the Chief Minister of Andhra Pradesh, wrote a complaint to the Chief Justice of India, S.A. Bobde, claiming that some High Court judges are attempting to protect the interests of the major opposition party, Telugu Desam Party, in politically sensitive matters. On November 25, top court stayed the Andhra Pradesh High Court's gag order on media reporting and social media comments on the contents of the Amravati land scam FIR. Bureau Report.
Former ICICI Bank CEO Chanda Kochhar faced a setback as the Supreme Court rejected her appeal against her sacking as the bank's chief executive and managing director. Chanda Kochhar, who faces charges for alleged money laundering and had approached the top court after the Bombay High Court dismissed her petition against her sacking.
The Supreme Court has refused to interface with the Bombay High Court's dismissal of a plea filed by former ICICI Bank Chief Executive Officer and Managing Director Chanda Kochhar against her termination in 2019. Even a senior advocate, Mukul Rohatgi, frequently urged the court to hear the matter. The bench of Justice Sanjay Kishan Kaul, Dinesh Maheshwari and Rishikesh Roy said, "We are not inclined to interfere in the impugned order. This falls within the realm of private contract between bank and employee. I am sorry, Mr. Rohatgi, we cannot interfere." Appearing for Kochhar, Rohatgi urged that it was not open to ICICI Bank to virtually recall the former CEO and MD's retirement. He questioned the move to terminate Kochhar on the ground that the decision was taken without the prior approval of the Reserve Bank of India. He submitted, "They have converted my resignation to termination. Whether the termination can be done without approving the resignation is a question." When Justice Kaul pointed out that the RBI granted its approval for Kochhar's termination, Rohatgi countered, "The employee is not covered under 35B of the Bank Regulation Act. How can my resignation be converted to termination? The RBI had no business to do this. You decided to go out on your own, but now you are saying they are terminating you. The bank is not sacking you," the Supreme Court said. Despite Rohatgi's plea to pose the matter for next week, the court ultimately declined to hear the matter. Chanda Kochhar had approached the Bombay High Court challenging the termination for cause communicated to her by ICICI Bank in January last year. A committee headed by former Supreme Court Judge Justice B.N. Krishnan had been appointed to investigate allegations that Videocon Industries were granted loans by ICICI Bank and quid pro quo Videocon invested in New Power Renewables, the company of Deepak Kochhar, Chanda Kochhar's husband. The Justice Sri Krishna Committee ultimately indicated Chanda Kochhar last year. In turn, the board of directors of ICICI Bank terminated her employment after considering the inquiry report. As a result, on January 30, 2019, the board informed Kochhar that it decided to treat her separation from the bank as termination for cause. Later, the bank revoked Kochhar's retirement benefits. Her efforts to obtain existing and future entitlements. Later, the bank revoked Kochhar's retirement benefits. Her efforts to obtain existing and future entitlements, including unpaid amounts, stock options, medical benefits, were refused. Thus, Kochhar approached the Bombay High Court challenging ICICI denials of her remuneration as Managing Director and Chief Executive Officer, as well as the order of termination. In March this year, the High Court dismissed the petition filed by Kochhar, noting that ICICI Bank was a private body and that the service condition of Kochhar are not governed by any state. Bureau Report.
The Supreme Court has set aside the directions issued by the National Commission for Protection of Child Rights or NCPCR to district magistrates and collectors across the country to send back children from children's homes to their parents in view of the COVID-19 outbreak. The NCPCR had made direction on October 9 this year.
Justice L. Nageshwar Rao and Hemant Gupta heard suo motu petition on the condition of child protection homes across the country during the pandemic. The court said the central government through Solicitor General Tushar Mehta had said children from protection homes shall not be sent back to their homes without scrutiny. The restoration of children shall be made only after complying with the provision of the Juvenile Justice Act, the court said. The order came day after the court asked for the second opinion on NCPCR direction asking for restoration of children lost in children homes. Solicitor General Tushar Mehta said the central had set aside NCPCR direction to district magistrate and collectors to mandatorily repatriate children in children's homes to parents. It said no child would be repatriated without following the requirements of Juvenile Justice Act. The Supreme Court has set aside the direction issued by the National Commission for Protection of Child Rights to district magistrate and collectors across the country to send back children from children's home to their parents in view of the COVID-19 outbreak. The court said the infrastructure will anyway have to be provided by the state, where the Legal Aid Service Committee and Child Welfare Committee of the area will also have to be involved. The state legal service authorities can probably be roped in, said the court, asking the amicus to send note to the source state, Bihar, West Bengal, Assam, where the children have been trafficked from. Meanwhile, amicus Agarwal has told the court that it needs to build infrastructure, have VC facilities in place, and a coordinator is appointed to speak to the children victims to ensure that they are not being pressured. Bureau Report.
In view of the ongoing corona crisis, the Delhi High Powered Committee has extended the bail of under-trial prisoners and convicts for 45 more days. The committee held that if interim bail is not extended, then chances of infection in jails due to overcrowding will rise.
Delhi's High Power Committee has decided to extend the interim bail granted to prisoners to contain the spread of COVID-19 pandemic inside the prisons for 45 more days. While noting that the COVID-19 cases in Delhi are still rising, the committee headed by Delhi High Court's PERS Judge Justice Hima Kohli highlighted that if at this stage the COVID bails are not extended and the under-trial prisoners and convicts are asked to surrender at this time, then it would be a dangerous proposition as they might bring with them the infection. The High Court Powered Committee was set up as per directions of the Supreme Court in the suo motu matter, recontagion of COVID-19, to decongest the Delhi prisons in light of novel coronavirus pandemic. So far, on the basis of the criteria set by the committee, a total of 5,114 prisoners have been released on interim bail, emergency parole till 27 November 2020. Director General had brought to the notice of the committee that if 3,499 under-trial prisoners and 1,183 convicts who have been granted interim bail under different criteria laid down by this committee are asked to surrender, then the total population of Delhi prison is likely to reach 20,500, which would be unprecedented and may become unmanageable owing to the present situation and circumstances. While observing that the COVID-19 situation in Delhi has become grim and if bail is not extended, then jail conditions can become risky for prisoners. The committee has further directed the Member Secretary of Delhi State Legal Service Authority to place this order before the Registrar General of Delhi High Court for seeking appropriate judicial order on the recommendations of the committee. In addition to the extension of interim bail granted to under-trial prisoners, the committee has also decided to extend the emergency parole granted to convicts for 6 more weeks. Bureau Report.
On December 7, a case against former Judge CS Karnan will be heard in Madras High Court. In view of the High Court has asked DGP and Police Commissioner to be present during hearing. The case relates to videos featuring Justice Karnan making derogatory remarks against judges and women.
The Madras High Court has ordered that the Commissioner of Police, Chennai, and the Director General of Police be personally present in court on December 7, when the petition filed for criminal action against former Judge CS Karnan will be taken up. In course of dealing with the case, the bench of Justices M. Satyanarayana and R. Hemlata observed that earlier this year, Justice M. Dhandapani of Madras High Court had passed orders for setting up of special cells by the police to track social media abusers. The single judge had directed that this measure be carried out by the police within 2 months. However, the DGP has not done the needful and not much headway appears to have been done, the court had observed. In this backdrop, the court sounded a critical note over the delayed action on the part of the police. The High Court has been dealing with pleas filed against the former High Court judge after several videos surfaced online featuring Karnan making derogatory remarks against judges and women. A complaint in the matter was first filed by Advocate Devika. In the meanwhile, the Bar Council of Tamil Nadu and Puducherry moved a writ petition in the matter. Thereafter, the State Bar Council also filed a criminal petition registering grievance over the slow response of the police in the case. In a counter filed, the police informed the court that 2 more FIRs have been registered in the same issue last week, one by the State Bar Council and the other by the Delhi Tamil Advocate Association. On November 10, the Madras High Court issued orders directing that derogatory remarks made by former High Court Judge Justice CS Karnan be blocked from social media. Karnan had served as a judge of the Madras and Calcutta High Courts before he was held guilty of contempt of court by the Supreme Court for making unfounded allegations against the judges of the top court. He was sentenced to 6 months imprisonment in that case and was released from prison in December 2017. Bureau Report.
We are joined by Advocate Shivam Sharma. Shivam, tell us about court's proceedings in this case.
Yes, in this case, the court sounded a critical note over the delayed action on the part of the police. The court remarked that if a preventive action would have been taken at an appropriate time, videos numbering 33 would not have been uploaded, and it also appears that incalculable damage has been done to the honor and reputation of the former judge as well as some of the sitting judges of the apex court as well as this court, and that apart to their family members, especially the woman folk. The court also said that it also prima facie appears that section 41A of CRPC is selectively resorted to, and it is not as if with respect of offences which are punishable 7 years and before. Therefore, the court has ordered that the Commissioner of Police Chennai and the Director General of Police be personally present in court on December 7th. Yes.
Thank you, Shivam, for joining with us. January 13 to 2021 onwards, Central Bureau of Investigation will once again start its submissions before the Delhi High Court in appeals against the acquittal of all accused in 2G Spectrum case. CBI appeals as well the appeal by Enforcement Directorate were listed today before a single judge bench of Justice Yogesh Khanna after Justice Brijesh Sethi released them from his board last month. The appeals are at stage of leave to appeal. CBI had made substantial arguments in its appeal before Justice Sethi on a day-to-day basis. However, with the retirement of Justice Sethi, the appeals have come before a new judge. Appearing for the investigating agencies, Senior Advocate Sonia Mathur urged Justice Khanna to take up the matter on a regular basis post-lunch. Senior Advocate Mathur added that CBI would take 3 days to conclude its submissions on the point of leave to appeal. While the court agreed to hear the appeals on a day-to-day basis, it stated that no date could be given before January 13, 2021. Consequently, the appeals were listed for hearing from January 13 to January 15, 2021. After the acquittal of all accused by the CBI court in December 2017, the CBI and the ED had filed an appeal in the High Court in March 2018. Last year, Justice Sethi had begun listing the appeals on an almost day-to-day basis. The same was, however, discontinued due to the disruptions caused by COVID-19. The Bombay High Court bench at Aurangabad ruled that allegations levelled against a police officer that he is involved in criminal activities and publishing news report regarding the same would not incite the force to act against the government. The bench of Justice T.V. Nalwade and Justice Shrikant D. Kulkarni allowed the plea of the applicant that case filed against him for the offence punishable under Section 3 of the Police Incitement to Disaffection Act 1922 be quashed and set aside. An FIR was registered against the applicant, wherein it was alleged that he made false allegations against respondent number 4. Harshvardhan Govind Gawali, Police Inspector and Sub-Divisional Police Officer Dilip Taprase by sending representation to his superior officer and by publishing news in local newspaper. It was the case of state that due to such publication there was possibility of creation of disaffection amongst members of police force, and that had created probability that subordinates of police commissioner may refuse to obey his orders, and that may also spread indiscipline. The High Court held that such comments questioning the wisdom of state government cannot lead to interference, that there was intention of the publisher to induce or incite police, which is requirement of Section 3 of the Act. It was further held that such disaffection needs to be created amongst police and it should be against the government. A letter petition has been filed before Allahabad High Court seeking suo motu action against a terrifying incident in Balrampur district of UP, where a journalist and his friend were allegedly charred to death by some unknown men on Friday midnight. It is alleged that the 37-year-old journalist Rakesh Singh and his 35-year-old friend Pintu Sahu were burnt alive in a house, leading to on-spot demise of the latter, whereas the former succumbed to his burn injuries during treatment in a hospital. The letter petitioners have sought a probe in the matter by Special Investigation Agency. They apprehend that crimes of such nature are on a rise, and it is a liability of the state to ensure its citizens' security of life and liberty. The petitioners have sought immediate compensation for the deceased family from the Victim Compensation Fund and have prayed that families may be given any suitable employment to their academic ability to ensure that they have a means of livelihood. The Karnataka High Court has directed the state government to make a statement before it on December 8 about the outer limit within which it will make appointment of chairperson to Karnataka State Scheduled Caste Scheduled Tribe Commission, which has been lying vacant since 2018. The direction was given while hearing a petition filed by social and RTI activist Maruthi. The plea states that the state of Karnataka ranks 7th in terms of crime against SCs and ranks 10th in terms of crime against STs, as per the 2019 data of Nation Crime Record Bureau. The report also observes that rate of crime against SCs in Karnataka has increased from 2017 to 2019. However, the conviction rate for such crimes in Karnataka has been extremely low. It is said that NCRB data proves that there has been no effective implementation of the legislation in place which looks at welfare and provides safeguard measures for persons belonging to SC or ST. The petition also mentions that 2.036 cases filed before the Commission since its inception in 2003, it has been dysfunctional for non-appointment of chairperson. There is an urgent need for strengthening the commission established under the Act. The petitioner has prayed for a direction to the respondents to effectively implement the Karnataka State Commission for Scheduled Caste and Scheduled Tribes Act. Further, appoint an interim chairperson to Karnataka State Scheduled Caste and Scheduled Tribe Commission till the post is filled officially by the state government. That's all for Courts Roundup today. Thank you for watching APN.
India Legal presents Courts Roundup.